morning. You can be seated. Thank you. Okay, so, well, this is probably better for them to hear.
Yeah.
Welcome to the morning session of the Kansas Court of Appeals. I'm glad you could all come. I've been telling people as we were here yesterday, my name is Karen Arnoldberger. I'm the Chief Judge of the Kansas Court of Appeals and a former student here at Johnson County Community College. I was just telling Mr. Nadelman that when he was telling us where we were sitting, I said, well, is that the old Little Theater? Because I remember this room very well. It just used to be called the Little Theater. But I went here and my husband went here and we had a wonderful educational experience here, and I'm just thrilled to be back, even though there are a whole lot more buildings here than there were when I went here over 30, many over 30 years ago. Hearing cases today, on my right is Judge Henry Green, who has been on the court now for 24 years on the Kansas Court of Appeals. To my left is Judge Patrick McEnany. He's also been on the Court of Appeals for many years, and before that, he was a district judge in Johnson County. So you've probably had at least 24 years of judicial experience. We have 3 cases to hear this morning. We'll just hear them right in a row. We'll have an opportunity to answer any questions you have at some point, but we certainly cannot answer questions about the case before us. You're going to see me up here with this cell phone, and as the presiding judge over the proceeding, my big job is to keep time. And so it's just to look at my clock on here, and I don't see one in the room. And I'm not, I just want to make sure you realize I'm not checking my email or texting while judging. When the parties step forward, if you will please state your name, and if you're the appellant, let me know if you want to reserve any time for rebuttal. All the cases this morning are set for 15 minutes per side of argument. Generally, we tell the parties, do not go over don't waste any of your 15 minutes going over the facts of your case, because we've read the briefs. In many cases, we've read parts of the transcript, so we know the facts fairly well, and we want you to get to the meat of your argument. But because we're doing this in front of students that may not be as familiar, I'll ask the appellant, if they don't mind, to take a few minutes and explain the facts of the case, and I will not count that against your time in argument. Okay, with that, if our first case is Eugene Keltner versus State of Kansas, if the parties would state their appearances, please.
Gerald E. Wells for the appellant, Mr. Keltner, Chief
And
Judge.
did you wish to reserve any time, Mr. Wells?
I do. 3 minutes, Chief Judge.
Okay, so 12 and 3.
May it please the court, Sean Manahan for the state.
Okay, thank you. And Mr. Wells, you can begin whenever you want. And like I said, I won't start your time until you've had a chance just to briefly describe the facts.
This case comes on what we call a 60-1507 motion, which is a traditional habeas corpus proceeding. It usually takes place, if not all the time, after someone has been convicted or there's been a direct appeal. And a habeas corpus petition is a device by which we challenge the lawfulness of the detention of our client or the defendant. That person is incarcerated, and so we are questioning whether or not he is lawfully incarcerated, and that normally leads to a discussion of constitutional rights. And my client, Mr. Keltner, raises a number of issues through that device, the 60-1507 motion.
Okay, thank you.
Judge, please the panel. I would like to take my time to discuss a couple of issues that I think are preeminent in this particular appeal. Firstly, I think the state downplays, and I don't think they should have, the importance of the notice that was given by way of a pleading in the 60-1507 that Mr. Keltner's trial counsel was conflicted. In other words, there was a conflict, and it's important to also note that that conflict was recognized in the state's brief. So it really is not in dispute that there was a potential substantive conflict.
And the conflict you're talking about, Mr. Wells, just for the benefit of the students here, is that the attorney that represented your client had been a pro tem or temporary judge in the court when your client came up on another case sometime earlier and heard the probation revocation hearing that your client had on another case and denied the revocation. And now this same attorney is representing him on his more serious charges.
Correct, Chief Judge.
Okay.
I think it's important to recognize a couple of cases that I've quoted in my brief. One is the State versus Taylor, and then the late case of State versus Cortez Brown. And what those two cases confirm was when a court has noticed that there may be a conflict in an attorney representing a defendant, then that court must inquire as to the nature of that conflict and whether or not there's prejudice in that conflict. And there's no question.
Before we get too far down, I just have a basic question about the claim of a conflict of interest. We tend to use that term in the singular, conflict of interest, but it's really conflict of interests, plural. That is, the lawyer has one interest and the defendant has another. His client has a different interest. So what are the competing interests here? What interest does the lawyer have that conflicts with the interest of the defendant in your contention?
Well, I would say that the fact that he sat as a pro tem in a revocation hearing, obviously in another case, as he sat there as a pro tem, as a lawyer, and as a judge, he had the interest to decide whether or not that revocation was appropriate and whether or not there was facts that would substantiate that revocation. Now, in that regard, he had to make some decisions, the lawyer, regarding whether or not that revocation should take place. Now, because the revocation was denied, it would appear on the surface that he did not have a particular interest, but the interest was obviously in conflict with Mr. Keltner's interest, because he had to decide whether that revocation should take place. So on the surface, maybe not, but underneath that, there was clearly, if, for example, he had said, I think there is reason for revocation here, that's obviously against the interest of Mr. Keltner.
But in fact, he didn't. In fact, he found in favor of Mr. Keltner and not only denied the motion to revoke his probation, but actually terminated the case, didn't he? Sent him on his way, ended probation. It was all over, wasn't it?
That's my memory. But I think it's also important to note, Judge, that the obvious important point here is that when this 60-1507 came up, the judge on the 60-1507, Judge Cameron, had the duty to raise that issue and to also determine whether or not there was a conflict, which was not done.
Wasn't that in the context of a ongoing case where the defendant said, my current lawyer, who is currently defending me in this case, has a conflict, and the court has a duty in that case to decide whether or not that lawyer should continue to represent the defendant. But here, that case is long over. In these proceedings, the lawyer's not involved.
No.
His case is all over. And I
But-
still don't understand at the time that he was representing, because the issue is, did a conflict exist at the time he was representing the defendant? And I still don't understand what interest he had that conflicted with the defendant's interest.
Well, if you take the basic premise that you can raise the conflict issue at any time, that's what Taylor says, that's what Cortez Brown. And the court has a duty to inquire. But this court never inquired about that.
Did he raise the issue
Yes.
with the district court?
No, he did not raise it with the
So
district
she
court.
was just supposed to, by telepathy, know that there was a potential conflict back there? Or
No,
how?
no, Chief Judge, but you can raise that issue clearly on a 1507.
Oh, I see what you're
That's the
saying.
remedy.
You're recognizing you didn't raise it below, but you're saying you can raise
Yes.
it now.
It was, in fact, raised, clearly.
Mm-hmm.
And that puts in motion a number of things. One is that if that is denied, if that petition or that motion is denied, that court has to make findings of fact and conclusions of law, which never happened.
Because
court said,
Judge
"Well, I
Cameron
don't-"
never knew there was a, Judge Cameron never knew, and the underlying case never knew there was a conflict. I mean, didn't have any reason to believe there was a conflict, did she?
But that's precisely why you have an inquiry under Taylor and Brown.
Okay.
And that's the basis of our position, that this court failed to have that inquiry, not only on the level of what Taylor and Brown says, but on the level of findings of fact and conclusions of law under 183,
There's a
Rule
there's a
183.
principle in these kind of proceedings, and broadly stated in these kind of matters, that if the trial court makes an error, we can act on it if it had some prejudicial effect on the defendant. But if the error was simply harmless, then we don't consider it. Now here, the court didn't consider that claim. Explain to me how your client why this isn't harmless. In other words, how, if it had been inquired into, the court would have found that the trial lawyer had a conflict of interest.
Which affected my client's
Yes.
rights. That's exactly the point, Judge. That is why not only 183, but Taylor Brown demands, if not mandates, that the court inquire. And the reason for that inquiry is to determine whether or not there's prejudice. And this is a threshold issue, because the court said, well, I don't find any evidence to substantiate the manifest injustice
But
claim.
don't you have to show, it would seem to me, that the court's error in not addressing that issue prejudiced me? Because if the court had inquired into that, the court would have found that there truly was a conflict of interest.
That's correct.
So don't you have the burden of showing that there actually was a conflict of interest that would have caused this case to be reversed?
Well, not until the court inquires. Not until the court inquires. The court, we don't know what the court would have said. I mean, we can guess, and there's reason to believe. But that's not the same thing as an inquiry that's demanded by Rule 183 in a differing form and Taylor and Brown in citation form. So that's our point. Now, also, the state claims that the new change in KSA 1507, which occurred in 2016, is retroactive because it's a procedural matter versus substantive matter, which the law is clear that it is not retroactive. So that really folds into our claim that the manifest justice issue is substantive and should have been addressed by the court under the case law and the statutes that and the rules that I've mentioned. So, manifest injustice is clearly, for years, has been defined as shocking to the conscience or basically unfair, or obviously unfair, I should say.
Okay, let me back up just a minute to give some background to the students. In filing one of these habeas corpus motions, a defendant is required to file it within a certain time period. And in this case, his motion was untimely. And so the only way he can avoid getting it dismissed as untimely is to make a claim that it would be manifestly unjust not to allow him to go ahead and proceed with this motion. And so now you're on the manifest injustice argument.
I should have explained.
That's hard.
better.
No, it's not your responsibility. It's
Manifest injustice is defined for purposes of, well, for every purpose given the 1507 motion that's available, is obviously unfair. Now, obviously unfair raises certain kinds of rights that are not only substantive but vested, and that is the right to have conflict-free counsel. And the reason that you should have conflict-free counsel is because that goes to your Sixth Amendment right to competent counsel, and that has been clear in the law for a long time. And so our position is that, firstly, this is a substantive right. It's not subject to retroactive application of that substantive right as the state would like you to believe. Secondly, as to the retroactive nature, nothing in the rule that was changed to accommodate the statute change indicates that it is a retroactive rule. They didn't state that. They didn't state it in the statutory change. They didn't state that as to the rule application as well. So again, this is such a basic right, a constitutionally protected right, that it's substantive and should be protected.
okay, and I'm going to head into your rebuttal time here.
This is a good break for me.
Okay.
Thank you.
Mr. Minahan?
May it please the court, Sean Minahan for the state. I think it's important to first point out that we first have to determine whether there's manifest injustice to even consider the underlying issues. Under Vontris, manifest injustice factors weren't set out by statute originally. Under Vontris, a case called Vontris v. State or State versus Vontris, the Kansas Supreme Court found that you look at the reason for the delay, why he didn't file it within the time period, whether he's claiming he's actually innocent of the crimes, and also whether he presents substantial issues of law and fact. On July 1st, 2016, the legislature amended that the 1507 statute to limit it to the reason for the delay and whether the defendant is claiming actual innocence.
Mr. Minahan, it doesn't bother me, but I don't wander too far from that
I'm sorry.
mic, if you would, because they're recording this for posterity, and we'd hate to lose the pearls that you're.
Yeah. I don't. This is a procedural change in the statute. This is how you judge whether there's manifest injustice. So, reason for the delay. The defendant in this case doesn't give a reason for the delay. I mean, he says that it's only, I think he says only 2 months late, but that's not a reason for the delay. That's just saying, that may be a factor in determining manifest injustice to allow him. And then actual innocence, he doesn't claim that he's actually innocent of this crime. This is an aggravated robbery that occurred at a Quick Trip. And the factual basis clearly establishes that he was the one that robbed the Quick Trip. Because of that, this court doesn't even need to get to the underlying factors of the underlying arguments. But even if you do, to establish his case, he has to show, since this is now on an IAC claim in the 1507, an actual conflict. And he doesn't allege an actual conflict. He just argues that there was a potential conflict. You know, I know that your honors have a lot of experience in the district court. If this would have come up in the district court in the actual case, and I think Judge Ruddick may have been the judge
I think he was,
originally
now that you
on it, then Judge Ruddick would have had a hearing, and they would have went over with Billum, Mr. Billum, the defense attorney, and the defendant, whether there was an actual conflict that made it so Billum couldn't represent him. So there's no evidence in the record that there was a diverging interest in this case between these two. Also, I would point out that Billum denied the revocation when he was the pro tem judge. So that doesn't really establish that he had some sort of a conflict with him. And I would also point out that the defendant in this case got a great plea deal. He was looking at, I think, 221 months in prison at a minimum, and received a 120-month prison sentence based upon it. And he was able to preserve his Uniform Mandatory Disposition of Detainers Act. It's a speedy trial claim for appeal. So he really didn't lose much in with the plea. And then finally, the sua sponte inquiry is based upon where you have a.
He didn't plead, did he? This was a trial, wasn't it?
I'm sorry, not a plea. It's a bench trial.
A bench trial.
Yeah, on, I don't know if it's stipulated facts, but it was a bench trial.
Right.
He waived his jury trial rights in return for, I think maybe an agreement on a departure or something. He got a downward departure. But the conflict between counsel and defendant didn't occur in this case. So Judge Cameron didn't have a duty to inquire whether, I think it was Ms. Schlimmer that represented him in district court. Whoever represented him in district court had a conflict with him. This was raised through an IAC claim, and that sua sponte rule does not apply, unless this court has any questions.
Questions? No. No, you can
Okay,
have a
thank
seat.
you.
Thank you very much. Mr. Wells, you have your 3 minutes.
Just a few comments, Chief Judge. First of all, I want to re-emphasize the fact that the sin here, if I can put it that way, is not that there is underlying facts which may go against my client. But the point is, I didn't think I was that bad.
You really offended them, Mr. Wells. Must be class passing time.
Yeah, I'll try to recover, Judge.
You can finish in time to make your next class, I think.
Yes. The point of it is that there wasn't an inquiry either that was mandated by Rule 183 or it is mandated, I sound like a broken record, by Taylor or Brown. For example, let us imagine that there was an inquiry and Mr. Billums got up on the stand under oath and testified, as he certainly would, without question. Mr. Keltner got up there and they testified under oath to facts that created such a conflict, even though it had not been stated before. Because as the panel knows, oftentimes, whatever conflict arises between client and lawyer occurs off camera, so to speak, and in a quiet place, and often in discussions that are confidential. So that's the reason why the court, Supreme Court, and in their rules and in their citations demand that an inquiry must take place, not only because it's a substantive right, constitutionally protected, but because under oath witnesses may come up with something that's not implicit or explicit, in the petition or motion under 60-1507. That's the point I wanted to make.
So your contention is that in this particular 1507, with this particular claim, the defendant does not have to show prejudice?
Well, he may have, but that we didn't get to that point.
No, I mean that the judge's error in not inquiring prejudiced him.
Yes.
Yes. You think, just so I understand your position, you're saying he doesn't have to show prejudice beyond that? Okay.
Not before the inquiry. Thank you.
Okay, thank you very much. We'll take this matter under advisement and issue an opinion, as a written opinion, as soon as possible. For the students that are still here, our internal rule within the court is we'll issue an opinion within 60 days of oral argument. You can check on Fridays at 9 o'clock on the Kansas Court website to see what opinions have come out. You can see both published and unpublished opinions on that website. All right, next is State of Kansas versus Albert Donette Taylor.
I'm Michelle Davis. I'm with the Kansas Appellate Defender Office, and I'm here on behalf of Mr. Taylor.
Okay, and did you want to reserve any time?
I do. How about 2 minutes? Would be
Okay,
good.
whatever you want, Ms. Davis.
That'd be great. Thank you.
State appears by James Krebs.
And we just approved your request to appear on this. So Mr. Minahan has passed the battalion to you on this, huh? Baton, not battalion. Thank you. All right, Ms. Davis, whenever you're ready, if you want to give a little bit of factual summary, I won't hold that against your time.
Mr. Taylor has
And
I'm
you're
sorry.
very soft-spoken, so
So, is this better?
it's better for me.
Mr. Taylor was in a one-car rollover accident in Johnson County, and when the law enforcement officer responded to the scene, he helped, the whole thing here was to get the vehicle righted, but the officer ran a check and Mr. Taylor's license was suspended. And so normally, the officer said he could have given him a citation for that, but the officer smelled marijuana. So the officer went ahead and arrested Mr. Taylor on the driving while suspended and searched the vehicle and found some marijuana debris in the vehicle and also some guns, 2 guns in the back seat floor of the car, of the SUV. The SUV had been, Mr. Taylor said the SUV had been rented by his girlfriend, and he denied any knowledge of the guns. So the officer says, I'm taking you to jail, and he drives to the, I believe it's called the Johnson County Detention Center, their jail facility. They go inside the secure car area, then they go into the processing area. And in the processing area, Mr. Taylor removes his clothing and his shoes and places them in a locker. And then the officer's pretty much done. Mr. Taylor goes into what they call the secure area of the jail. The officer goes back and looks at his clothes and shoes and discovers a little bit of marijuana in one of the shoes. So as a result of that, the state charges, and Mr. Taylor's convicted of possession of marijuana, trafficking marijuana into a correctional facility, which includes a jail, the driving while suspended, and then also theft of one of the guns that's found in the backseat of the SUV.
Because the gun was apparently found to be a stolen gun, is that right?
The state had some interesting creative legal theories here in regard to obtain these convictions. And so we raised numerous issues in this appeal, challenging these convictions in many different ways. Sufficiency of the evidence on both of them, because in order to traffic contraband into a facility, the statute says you introduce any item into the facility without the consent of the administrator. And I think there's a case that's talked about this that says if you read this statute literally, you'd have to walk into a jail naked, because it says any item without the consent. And the state's theory here is once he goes into the facility, once he's driven into the facility by the officer, you've introduced an item into the facility. So there's a case on this, Watson, the Kansas Supreme Court, that says obviously the statute's very vague, and in order for that statute to be okay, they said that once the administrative facility determines that an item is prohibited, you have to give adequate warning to anybody who may enter the facility that this conduct is prohibited and that it's also a crime. And basically, in this case, the state says, no, we don't have to give any adequate warning because it's marijuana. So he's supposed to know you can't take that into a jail. And then also, we don't believe he was taken to the jail. So he didn't introduce the marijuana into the jail. The officer did by taking him into the jail and not searching him beforehand. So we've got a sufficiency of the evidence claim there. We've also got prosecutorial misconduct because the prosecutor, or prosecutorial error, I'm sorry, because the prosecutor said we don't have to give him adequate warning. He's supposed to ask. He's supposed to ask before he's taken into jail, is it okay for me to do this? Or we don't have to give adequate warning because it's marijuana. And so the defense counsel at the instructions conference said, Judge, we think you need to tell the jury in accordance with Watson that the state has to prove that they gave him adequate warning, because that's our defense here, is he wasn't giving adequate warning, and the judge denied that request. So there's an instructional error there, because if the jury had been instructed that the state has to prove adequate warning, then it's our position they wouldn't have convicted him of this crime, because clearly there was no warning given. And then also the state charged.
Excuse me, on
Yes.
that warning about the marijuana, taking
Yes.
marijuana into the, you say that the sign didn't notify him. Wasn't there evidence that he was acting very uncomfortable and nervous about his shoes? I mean, it wasn't just a little bit found. There was a baggie of marijuana in his shoe, right?
But it's too late then. He's already in the jail. I mean, the state's theory here is once you went into the secure area and they had testimony, that was the officer's position. The officer's position was that he's guilty of possession of marijuana. He told Mr. Taylor, if you had taken the marijuana back into the secure part of the jail, then you would have been guilty of trafficking. But the prosecutor in the state was very clear, once you go into even the car area, any part of that facility, you've trafficked. And so that was their theory. And they had one of the people testify that that's part of the facility, the part where the officer drives in and the processing area before he even gets to the locker.
Where is it they
Is
put
all part of the jail.
Where is it they put I'm assuming they have some sort of notice there listing.
No, there's no testimony about that. No,
There's
there was a
no
sign.
testimony about any signage.
There was a sign saying, the officer said there's a sign saying no firearms. That's it.
Okay.
No other sign.
At first, they said it wasn't a notice, but then the
Right.
officer went back and checked,
Right.
and it was no notice as far as contraband. Is this firearms and things of this nature? Nothing
right.
about drugs. Is that correct?
That's right. But, it's not just that there's no firearms allowed. There's a Colorado case that Watson, our Supreme Court, relied on that says you have to give warning. You're going to be prosecuted for a felony. It's not just don't bring this in here, but you're subject to felony prosecution if you do.
So nobody is arguing that he shouldn't have been charged with possession of marijuana. The question is whether he should get the double whammy of trafficking marijuana into an institution, correct?
That's right. That's
Yeah.
right. And that's a serious charge. That's a level 5 felony, and he's 3 years in prison for that. So this had serious consequences for them. And the other grounds the state relies upon is that because everybody knows it's a crime to possess marijuana, you should also know it's a crime to take it into the jail. But those are two different things. I mean, every statute requires criminal intent. And the criminal intent to traffic is different from the criminal intent to possess. I just don't think that argument holds any water. And then also, the state charged that he intentionally introduced this item into the facility. But trial counsel, defense counsel objected. The judge instructed the jury, he broadened that charge. And the judge instructed the jury, you can find him guilty if he knowingly or recklessly did so. So in closing argument, over counsel's objection. So the judge gave the state, lowered the state's burden and made it easier for the state to convict him. Because in closing argument, trial counsel says, he didn't intentionally do this. And the prosecutor gets back up and says, but he could have knowingly or recklessly done it. He put marijuana in his shoe, so he should have known it was in there. or that was reckless for him to do that. He should have anticipated I could get arrested and I could get taken to jail. So his conduct was reckless. He recklessly trafficked. So that broadening of the instruction prejudiced the defense because it gave 2 additional theories that the state could convict on that weren't charged in the original complaint. And again, that's a due process violation. So those are all, we list several reasons why that conviction's bad. And I'm not
What
sure.
did the charging document say?
Intentionally.
Intentionally.
Okay, thank you, I'm sorry.
And then, I'm not sure how much time I have left, but we also challenged the theft conviction because, again, it's our contention that the theft is the original taking. The state, there's several ways to commit theft. One is basically what we think about as taking, exerting unauthorized control, exerting or obtaining unauthorized control. The state didn't charge that. The state brought in a witness that said, I'm sorry, the state did charge that. There's also possession of stolen property, knowing it's stolen. So the state brings in, this is Johnson County, the state brings in a witness that the previous year his gun had been stolen in Kansas City, Kansas. And so the defense here was there's no evidence that Mr. Taylor was involved in that theft. And again, the prosecutor told the jury it didn't matter. The state did not charge that he knew the property was stolen. The state just charged straight up theft, that he obtained or exerted unauthorized control, and he doesn't have to know that the property is stolen. So the state convicted Mr. Taylor of theft by telling the jury that we don't have to prove he knew the gun was stolen. We just had to prove he was in possession of a stolen gun.
So they made it a strict liability crime.
Right, right. And
So what about their argument of saying is that because here in Kansas in the legislature, having a firearm is heavily regulated, and therefore it's really, if you get it by nefarious reason and it turns out to be stolen, then it automatically, that shows that you should be found guilty of theft under that situation. Did you come across any law that's saying that they're so heavily regulated in Kansas that you can be found guilty even if you didn't know that the firearm was stolen?
No, I did not find any case law that says that. The reason theft of a firearm, normally theft is a felony or misdemeanor depending on the value of the item stolen. With a firearm, it doesn't matter. It's a felony if you steal a firearm. That's the only way that a firearm is distinguished. That does not make theft of a firearm somehow different from regular theft. It's just a sentence classification difference. And I don't know of any law that says that guns that have to be registered or bought at a gun shop. I mean, the implication here by the prosecutor was that he must have been involved in the theft. And that's all it was an implication. There was no evidence of that. Let me think if I've got all of my arguments there on that. I think the thing that's really bizarre about this for me is in order to have a theft, you have to intend to permanently deprive the owner of the property. You have to have that intent. So the state's argument here is, well, it was unauthorized control because the gun was stolen. But at some point, how do you intend to permanently deprive the owner if you don't know you're depriving the owner? That's what I don't understand. And the state, even on appeal, is saying we don't have to prove he knew the gun was stolen. Well, how can you have an intent to deprive if you don't know you're depriving? I don't understand that basic concept.
Well, you need to listen carefully at the state's argument in a minute.
Well, I will pass.
The
On that
veil will
note.
be lifted.
Thank you, Ms. Davis. All right, whenever you're ready.
Your Honors, to briefly address some of the things that Ms. Davis talked about. First, to the sufficiency of the trafficking charge. Watson was not a case about sufficiency of the evidence. It was a facial constitutional challenge to the statute, finding that you have to have notice in order for there to be essentially a due process, or no notice equals a due process issue, not that it's an element of the crime. Here, we do have notice in this case.
But when you talk about Watson, help me out. Watson said it was not, the challenge Watson was making was saying this statute was facially unconstitutional. Then our Supreme Court saying that is a high burden. That's a big challenge, and you can't make that challenge here. You don't meet that burden. But what we're going to find here is that it was unconstitutional as it applied to you. That's the reason why we're going to say that you have to have notice. I mean, do you disagree? That's what Watson held. And what we have here in this particular case, we have this defendant is challenging what happened here and saying a lack of notice, is saying that as a way it's applied here, it's unconstitutional as it applied to me. We don't have this defendant challenging that, saying it's facially unconstitutional. Do you agree?
That's correct, Your Honor. This is an as-applied challenge. I believe issue 4 in this case is an as-applied challenge.
Okay. You could go ahead.
Okay. And here, Your Honor, this goes to both the kind of the sufficiency and the constitutional challenge. We have the statute gives notice that controlled substances are essentially contraband that cannot be brought into a correctional institute. The statute specifically lays...
The statute talks about any items. That's the problem. Any items. And there's no limitation to any items. And I think that's what Watson was saying, that the administrator who's in charge needs to tell the public what any items mean as far as notice. Do you agree?
I would agree with that, Your Honor, and I think perhaps it's best to draw a distinction between this case and Watson. Watson involved a person bringing cigarettes into a correctional institute. There is no language in the statute saying cigarettes of any kind. It relies on that any items. A reading of the statute provides that bringing in, I believe it's firearms, ammunition, explosives, and controlled substances as listed under Kansas statute is a severity level 5 felony. That gives notice that there is no, bringing in a controlled substance creates or essentially violates the statute. That is where the notice comes from, Your Honor.
But the notice that y'all had when that person was being brought in, it didn't say that. You're talking about what's in the statute, another statute. I mean, you didn't have, when he was taken in, you didn't have a notice saying that bringing in any drugs will be considered contraband. Is that correct? I mean, it seems like the record is undisputed. You didn't have that type of notice.
That's correct, Your Honor. I believe the sign only mentioned firearms.
Firearms. Okay. So that's kind of distinguished from the statute. You're saying that because there were drugs, he should have known. But when you look at Watson, Watson was talking about generally ignorance of the law is no excuse. But Watson went on to say that it requires a due process. Even though we have this rule, ignorance of the law is no excuse, then they were talking about the notice, and notice is required to have due process. Do you remember reading that in Watson?
Yes, Your Honor. And I would once again differentiate these two cases.
Okay.
Watson was based upon that any item idea of, well, how is a person to know that they can't bring cigarettes into a correctional institute unless it explicitly says? Here, the statute explicitly says that there's no controlled substances, which is what we have. If a person is deemed to have knowledge that you can't bring in items into a correctional facility unless you have the consent of the administrator, certainly they're also deemed to have knowledge that that certain items, including explosives, firearms, ammunition, and controlled substances, are banned by statute as well. And here, Your Honor, to the sufficiency, there certainly was intent, or there is certainly evidence of intent to introduce those items. We have Mr. Taylor, when he arrives, he goes through the booking process, which there was testimony that both the booking area and the Sally Port were part of the Johnson County Adult Detention Center. We have Mr. Taylor, when the officer asks him for his shoes and his coat so he can put them in the property room, Mr. Taylor seems very nervous. He takes off his shoes, which are muddy, by the way, and wraps his coat around them. I should say first he tries to take his shoes into the facility before the officer stops him. These show that Mr. Taylor intended to hide that marijuana in his shoe. He intended to have it in the Correctional Institute. This is different than, say, I believe the Conger case this court decided, which I believe that was an unpublished decision, Your Honor. But in that case, this court determined that when a woman essentially forgot about I believe it was a Seroquel pill in her shoe, she didn't have the criminal intent necessary to introduce the item into the facility. However, Your Honor, I believe the key distinction between this case and that case is in that case, the woman handed the pill to the officer after the officer gave her the jail clothing and gave her, I believe, the jail shoes and said, "Here, change." She hands the pill to the officer and says, "I forgot about this, I'm sorry." And the court found that that didn't satisfy criminal intent. Here we don't have that. We have Mr. Taylor apparently hiding the marijuana in his shoe and attempting to hide it in the Correctional Institute.
Well, that argument can go. He was trying to avoid being charged with possession. And he was. He hadn't been charged at the time, correct?
That's
with
correct, Your
possession. So he could have been trying to avoid getting in charge of possession and not, the arguments that you're making, to avoid the charge of possession in acting in the way he did.
Yes, Your Honor, but by avoiding the charge of possession, he intentionally introduced it into the Correctional Institute.
And that's the problem with the rub here. Shouldn't he had noticed that saying, okay, if you do bring drugs in, you're going to be charged with a level 5 felony. It's not going to be just simple possession. You're going to be charged with a level 5 felony. Don't you think you should get notice?
You should get notice, Your Honor, and the statute gives that notice.
Well, to save, if we accept that argument, that the statute gives notice, so he had notice, he can't bring it in. To save this conviction, you still have to get beyond the instruction in which you charged this fellow with intentionally bringing it in, but told the jury in the instructions and in closing argument that intention doesn't matter, whether he intended to or not. If he just recklessly brought it in or knowingly brought it in, that's enough. Don't you have to, you need that in order to save this conviction, don't you?
Yes, Your Honor, and while the expansion of the jury instruction may have been error, it was harmless. Mr. Taylor wasn't prejudiced in this case. This court, in looking at those kind of expansion of expansion of instructions from charging documents, has basically looked at whether the defendant was prejudiced. Wade uses, I believe it was Wade, and I'm sorry if it's not, but it uses the term trial by ambush. We don't have that here. Mr. Taylor relies upon Trotlov and Wade to essentially make the argument, and those cases are very different from the one we have here. In Trotlov, we had a sexual exploitation of a child, which was charged by displaying an image. Evidence, the jury instruction included, I believe, procuring and producing, which wasn't charged, and which constituted the majority of evidence at the trial. In Wade, we essentially had the court essentially expanded the initial charge of intent to commit murder to intent to commit aggravated assault in the context of, I believe it was a felony murder in that case. Here we don't have that. Mr. Taylor never argued that he only knowingly had marijuana in the Correctional Institute. Instead, trial counsel rested their arguments upon the idea of notice. There was no notice that he didn't have any notice that he could introduce it. There was no argument that, oh, well, maybe he only knowingly introduced it as opposed to intentionally did it. And as such, he's not prejudiced by this error. Your Honor, speaking briefly on the theft issue, Kansas statute, and I should say Mr. Taylor was charged with obtaining and exerting unauthorized control over the firearm. Obtaining and exerting control, the state doesn't have to prove that Mr. Taylor actually stole the firearm. Kansas statute provides that obtaining and exerting control is taking, carrying away, sale, conveyance, transfer of title to, interest in, or possession of property. And here we have that. We have unauthorized possession of property with the intent to permanently deprive the owner. And the intent to permanently deprive the owner is clearly shown.
Well, can he?
Go ahead.
No, go ahead.
Well, let me ask you about this argument that the prosecutor made down below when they were talking about that. And I quote part of it, and he's telling the jury, you have to have that gun, you have to have unauthorized control over the gun, and it has to be a firearm. Because firearms are regulated, and it's meant to be encourage people to go through proper channels registering firearms. Buy from a gun retailer. You get that gun through nefarious means, and it is stolen. Tough break. It means you are guilty of theft of a firearm. I don't hear anything saying you have to be intentionally as far as knowing, or as far as this item is stolen. But the bigger question I have, where is it regulated that you have to buy firearms from an FFL dealer in Kansas? And Kansas is one of the most liberal states in the whole union as far as possessing firearms. You can buy firearms from a private individual all day long, and it's not regulated. And you don't have to go through a background check. You could go to one of these, when they have gun shows and things of this nature, you have people walking around, private sellers who are willing to sell their firearms, and it's not regulated. They don't have to go through a background check. So we're in our law, in Kansas law, it says, because it's highly regulated, that because if you don't have it registered, therefore, if it turns out to be stolen, then, and you possess it, you are automatically guilty of theft under the statute we're talking about. Where is it? I couldn't find that law. Is there a law out there that says that?
I don't believe there is, Your Honor. I believe what the prosecutor was likely referring to is that idea of normally improving a felony theft, you have to prove that it was the item stolen was worth at least $1,000. I believe the prosecutor was likely trying to refer to the idea that you don't have that monetary cap because it is a firearm, and the legislature has chosen to make that decision.
But the jury was confused because they came back and asked for a definition of theft of a firearm, specifically, in this record. Isn't that correct?
That is correct, Your Honor. And I would also say, Your Honor, when it comes to that, it was actually defense counsel that confused the jury in talking about whether the state would have to show that Mr. Taylor actually stole the gun from Mr. Brown, physically took it. But that's not what the state's required to prove.
But you can't, when the prosecutor err, even if the defense say something that's incorrect, you can't jump on that and create an even more error in telling, a more serious error in telling the jury your point of view. That's still error.
Yes, Your Honor, that's likely the case. And, Your Honor, even if this was error, it's still harmless. The state presented ample evidence that Mr. Taylor intended to permanently deprive Mr. Brown of his firearm.
He was driving in a rental vehicle, right? It wasn't his vehicle, right?
It was a rental vehicle, Your Honor.
Okay.
But Mr. Taylor was the sole occupant of the vehicle. Mr. Taylor denied knowledge of the firearm. Subsequent tests revealed that Mr. Taylor's DNA was found on the firearm, and he still continued to deny knowledge of it. That shows with circumstantial evidence his intent to permanently deprive Mr. Brown.
Well, that shows that he knew there was a gun there. In fact, it handled a gun. The question is whether he knew that gun had been stolen.
Stolen.
What's the evidence that he knew the gun was stolen?
Your Honor, I believe the evidence that he knew it was stolen goes to his statements to the police. He stated he didn't know anything about the gun. He had no knowledge of it.
So you think the cover up?
Stating I don't know anything about it proves that you do know about it. Is that what you're saying?
I'm saying that might be the case, Your Honor, when his DNA was found on it.
Well, yeah, but I think everybody concedes that. He knew the gun was there. He handled the gun. His DNA's on the gun. I think the issue is whether he knew it was stolen.
Saying, Your Honor, I would submit that that circumstantial evidence of that goes to show that he
So
had
you
that
think the
intent.
fact the cover-up was circumstantial evidence that he knew it was stolen?
Yes, Your Honor.
Is what you're saying?
You can prove somebody's guilty when they plead. The fact that they plead innocent proves they're guilty, right?
No, Your Honor. That's
Well, that's
I'm-
obviously they're trying to cover something up.
Your Honor, it's more than simply that. It's the knowledge or the sole possession of the gun, the fingerprints on the gun, and then the subsequent denial of any knowledge. All of those together create or show that knowledge.
But you're
and intent.
still arguing on appeal, aren't you, that we don't even have to get to that, because all we're required, you're basically saying that possession of a firearm is a strict liability, of a stolen firearm is a strict liability offense. You didn't have to know it was stolen. All you had to do was possess a stolen firearm.
No, Your Honor, that's not
Okay.
what I'm saying.
Okay, tell me what you're saying.
I guess just for clarity, are we talking about the sufficiency argument or the prosecutorial error argument?
Whichever one you want to talk about.
Okay. I guess to the sufficiency, sufficient evidence was presented, especially in the light most favorable to the state, that a reasonable jury could have found that. To the prosecutorial.
Could have found
Could have
that
found
he knew it was
Mr.
stolen.
Taylor. Yes, could have found Mr.
Okay.
Taylor guilty. I'm sorry. To the error argument, the prosecutor's statements were, like as I said, likely directed toward that idea of the Kansas legislature has placed firearms in a special category where you do not have to prove dollar amounts and things like that. And Your Honors, if there are no other questions, I believe.
Well, I've got another question. I want to go back to that.
Please.
Go back to that introducing contraband into the county slammer. You say he's on notice of this by the statute that says you can't bring this stuff into a detention center or a prison or any corrections institution, right?
Yes, Your Honor.
All right. He's charged with intentionally bringing it in. Is that right?
Yes, Your Honor.
The jury is told, even if he didn't intentionally bring it in, you can still convict him if he knowingly brought it in or recklessly brought it in, right?
I believe the prosecutor made, maybe one mention of it.
Well,
His
it was in
focus on
instruction,
intent.
wasn't it?
Yeah, oh, yes,
The
Your
court
Honor. Yes, Your Honor.
told the jury that.
Yes, Your Honor.
So this guy he's in this rollover accident. The cops come, they arrest him, they haul him down to the detention center. He knows he's got the stuff in his shoe. He knows it's illegal to have it. But he's going to jail. He's got no get out of jail card. He's going to jail, whether he likes it or not. And the marijuana is going with him because it's in his shoe. So he could, in those circumstances, he could have knowingly brought it in because he knew it was in his shoe, but he didn't intend to bring it in because he didn't intend to be hauled off to jail in the first place. Isn't that true?
Well, Your Honor, I would say.
So what I'm saying is the jury could have convicted him on the grounds that, well, he didn't intend to take it in, but once the cops had him, that's where he was going, and so he knew that was going to happen.
Well, Your Honor, essentially all of the argument in the case was related to intentionally, and Your Honor, based upon Mr. Taylor's conduct once he got in the jail of attempting to wrap his coat around his muddy shoes, of his nervous behavior, all of that shows his intent to
Well, it shows
introduce
that he knows that there's the marijuana there and he doesn't want it to be found. Does it prove that he intended to bring it in, as opposed to being forced to bring it in because he was in custody of the police and he couldn't get it out of his shoe and they wouldn't roll down the window so he could throw it out of the police car before he got to the jail?
Your Honor, I believe this court's Conger case addresses that issue, and looking at that issue, Ms. Conger's giving of the pill to the officer basically negated her criminal intent to introduce it into the facility. We don't have that here. We have Mr. Taylor.
Where was the pill in that case?
I believe it was in her shoe as well, actually.
Okay, so let me ask a question here, just because I'm not clear on how this works. So their clothes are taken, their shoes are taken, and are locked away because they're given an orange jumpsuit and shoes to wear, right?
That's my understanding, Your
Okay,
Honor.
so he's never gonna, whether they find it in his shoe or not, he's not gonna have access inside the jail to that contraband, right?
Inside
Where the people are held. Isn't the purpose of trafficking in contraband to prevent contraband from getting inside the jail so that people will use it and use it in jail, barter it in jail? This was never going to get into the jail. And does that go back to Ms. Davis's comment that your argument is the minute they come into the Sally Port, he's trafficking in contraband because he's allowing himself to be moved into the jail facility with contraband on him? That's trafficking. Is that your argument?
Essentially, Your Honor, and it goes back to the way the statute is written. And I guess perhaps looking at, I believe it's the Carrillo case from, I believe, Illinois, which I believe the Supreme Court relied upon in Watson. In that case, that court determined that leaving, I believe it was alcohol, out in the vehicle was not, did not violate their statute.
Right.
But it did so because it was an intrinsically innocent item that a person would have no notice that they were in the facility at that time.
But it just seems to me that the term trafficking in contraband implies something more. It implies an intent to get it into the facility so that you can barter with it, use it once you're in there, whatever. The mere fact that you've, I guess that's just my thought. Any other questions? Okay, thank you very much. We went way over your time with questions. You got a trial by fire on your first oral argument.
Just for my 2-minute rebuttal, a couple of brief comments. This was not on the theft charge, and we don't have to show the defendant knew it was stolen. This was not some casual comment in closing argument. At the end of the state's case, trial counsel moved for a acquittal, saying the state hadn't proven a theft. And the prosecutor argued that same theory to the trial judge. And that site, it's in my brief, it's at volume 6, page 8. The prosecutor argued a person who comes into possession of a stolen firearm, whether the person knows it's stolen or not, is guilty of theft. So, I mean, this was the state's theory of the case. Mm-hmm. This wasn't a mistaken comment. And then on the trafficking contraband, the way the statute reads, trafficking contraband, trafficking item is going to be a level 6 felony. And it's a sentence enhancement if the item, there's several ways that it can be a level 5. But the way that the state's talking about is if it's a firearm, ammunition, explosive, or a controlled substance defined in KSA. So what's a controlled substance defined in KSA, right? Methylphenidate is a controlled substance defined. What's methylphenidate? A lot of people know it as Concerta or Ritalin. It's prescribed for ADHD. When something's a controlled substance, all it means is it's regulated. And you better have a prescription if you're going to possess it, generally, at a minimum. There's some things you can't get a prescription for, but that's all a controlled substance means. Methylphenidate is listed in Schedule 2. It's commonly prescribed. That's a controlled substance. That's what we call a controlled substance. You got to get a prescription. So just because it's a level 5 felony doesn't mean most people think, well, I can't take my ADHD medicine into the jail. I don't think that's conveyed in the statute. What's conveyed in the statute is if it's an item that the administrator has said you can't bring into the facility and you do so, then you're going to be, and it's a controlled substance, which includes prescription medication, then you're subject to a level 5.
So the controlled substance argument is more of a sentencing provision, is what
Yes.
you're saying, than it
Yes.
is a statement that
Right, it's all just the sentence enhancement. It's also a sentence enhancement if the Secretary of Corrections has enacted regulations defining it as contraband. But even the state lists the regulations in its brief, even those say that the warden hasn't approved. They're all items the warden hasn't approved. So I mean, this language doesn't tell you anything. I mean, basically it's everything. I think it's gonna end up being a level 6, but Seroquel. I believe Seroquel's a prescription medication.
Right.
I mean, and the difference in that case is that she had Seroquel, and the state prosecuted her because they said she was taken to the booking area and she should have given the Seroquel up at that point. And then when she didn't, she was taken into a holding cell, and when they were searching her, that's when she gave up the Seroquel. So, I mean, the same argument's there, right? That's why the state prosecuted her, because they said, well, she should have given it to us before. So by taking it into the holding cell, that's showing some kind of intent, and that wasn't enough for the Court of Appeals. They said there's no intent here to traffic.
And doesn't it go back to that idea that the idea of trafficking is to take it into the jail, to
That's
barter,
right.
to...
That's right.
It's something different than mere possession.
That's right. But the legislature writes these broad laws. I mean, if I was a defense attorney in Watson, I would have said, you got to strike that statute down. It's unconstitutional. Right. And courts say, no, we're going to read it this way, and we're going to require this in order for the law to be constitutional, which is fine, but then you kind of need to tell the jury that. And that's what didn't happen in this case.
Well, so you're suggesting that in any case, you could never instruct on intentional, knowing, and recklessness when it comes to trafficking. You're saying it always has to be intentional.
No, I'm just saying the way the state charged it.
Well, but let's...
the statute doesn't say.
If trafficking involves the intent to trade drugs introduce drugs into the prison for the purpose of bartering them, it has to be intentional in every time. You couldn't. It couldn't be reckless, could it?
Well, the statute does not prescribe a mental state. It just says that you introduce. And so the mental state is required by a different statute.
And that's what says knowingly, recklessly, or intent.
Right, so it's under the new codification,
Right.
where the statute that requires, if it doesn't have a mental state, you got to put one in.
But by the
And-
nature of trafficking, the very nature of trafficking suggests to me anyway that knowingly or recklessly
Right.
are not
Yeah.
viable
Yeah.
mental states when it comes to trafficking drugs in prison.
Well, it's that state's rebuttal to the defense argument that I forgot. I forgot it was in my shoe. So that's where the knowing comes from, right? You should have known,
Okay, all right.
or we can't believe the defense, he should have known. I think that's the fallback. So that concludes my comments.
Okay. Thank you very much.
Okay, thank you.
Thank you. We will take this matter under advisement and issue an opinion as soon as possible. And last, we have State versus, I'm not going to be able to pronounce that. Can you pronounce it, Ms. Davis?
Santia Pillai.
Santia Pillai.
We'll go with that, Mr.
And
Santia
who's
Pillai.
arguing from Johnson County? Okay.
Your Honors. Jacob Gontes County, half the state of Kansas.
Okay, and Ms. Davis, did you wish any rebuttal time?
2 minutes would be great.
Okay, and if you want to give this has some kind of interesting facts, if you want to give a brief synopsis of that.
Well, this is a case again here in Johnson County, and this is where DEA agents, which I believe is drug enforcement, go out for coffee. Being the alert officers that they are, they noticed the defendant appearing to try to withdraw money from 2 or 3 different ATMs. It sort of, my understanding was kind of in a close area, or at least that they observed on their drive. So they went back to the office and they talked about this.
Well, he was walking up to the drive-through.
Oh, that's right, walking up, right, walking
So he
up.
wasn't driving
Okay.
through, he was walking up to the drive-through bank teller.
Right, and then I think when they were driving back, they may have observed him again, but I'm not sure. Or maybe they were just in their car and they kind of watched him a little bit. So they go back to the office and they talk about this, why somebody's going to 2 or 3 different ATMs. And then another DEA agent is leaving work that day, and he also sees the person matching the description leaving an ATM. So he stops him, and he sees that he has several blank cards in his hand, gray, and one of them has a number in it, and tries to engage in conversation, which the defendant doesn't want to do. And so the DEA agent calls local law enforcement and arrests the defendant, and then from there searches him and finds evidence used by the state, cash and cards, that they used to prosecute him. And then as a result of that, the officer goes to the hotel room and finds, I think they call it a re-encoder, possess a re-encoder, which is where you apparently use that to put the credit card number onto the card so you can go and use it. So as a result of this, the state convicted him of possession of a re-encoder with intent to defraud, and also 18 counts of identity theft for possessing all the numbers that belong to other people, and then 13 counts of misdemeanor theft for the actual transactions at the ATM for the cash that was withdrawn. So I think that the issue I want to talk about today is the sentence issue, because these are property crimes, and so under the Kansas sentencing guidelines, we want to reserve prison space for people like Mr. Taylor who are trafficking in contraband, and for people that commit violent offenses and sexual offenses and drug offenses. And so normally with a property crime like this defendant would have gotten probation. At the time of sentencing, he had been in jail for 22 months. He had paid back restitution, or restitution was paid back around the time of sentencing of $38,000. The Kansas sentencing guidelines, which are set by the legislature, said this was a presumptive probation crime. The maximum sentence on the primary offense would have been 19 months. The state moved for a dispositional departure so that he had to go to prison, and the state also moved for a durational departure, which allowed the judge. The maximum sentence the judge could have imposed would have been 38 months on all counts because of the double-double rule. But in this case, the state, the judge doubled the sentence to, and he ended up with 70 months by the time you run the counts consecutive. The issue here is that the state, because the defendant was a citizen of Canada, the state's position was that he could not be placed back on probation in Johnson County because he would be deported. And the defense position here is, yes, I can do a probation. They send me back to Canada, I'll do it in Canada, just tell me what you need to do. And so there's case law that says that just the fact of being your alien status, for example, the fact that he's a citizen of Canada isn't enough to deny probation to someone. And the reason the state asserted in this case is that the state said he wasn't amenable to probation because he was going to be deported. And the district court said there's no program of probation that exists here. So basically the way the court was looking at this is that we have our standard Johnson County Community Corrections probation, and that would require you to get a job and report in, or et cetera, et cetera. And he can't do that. And I think our position here is based on the case law, that basically the judge just jumped ahead of himself, that at some point he needed to order the probation, and order probation or try to work with the defendant in a probation that would work for him. That just saying you don't qualify for probation because you're not a citizen of this country isn't sufficient. And so we're challenging the dispositional departure on that basis. And then also,
Well, didn't he explicitly say, well, I'm not doing this because you're, well, actually, at this point, he was an illegal alien because he was in the United States on a 6-month visa, and the visa had expired, and he was no longer permitted to stay in the country.
that was testimony about that, yes.
And he's just saying, well, that's part of it. It's got to be part of it. That's an essential part of the argument, of the analysis. But he's saying the real problem is we don't have a program that suits you, that'll work for you, because Canada, we can't send you back to Canada, have them supervise the probation,
Right.
because this isn't a federal charge. And if you're under community corrections supervision, you'd have to, you're at the detention, residential center, you gotta be working, and you can't work if you're an undocumented alien at this point.
Right, but I think the position here, I think the judge just would not contemplate is, I get sent back to Canada, this is what I'm supposed to do. I mean, he'd already been in jail for 22 months, he paid back restitution. So what would the other probation conditions be? You maintain employment, you pay back the court costs, I don't know. But these are things that he could have done in Canada, and he could have complied with them by distance or through counsel. It's possible.
Without anybody supervising, explain how that would work.
Well, you would just still be supervised, you just wouldn't necessarily report it, you would report by phone or whatever it is.
You say being supervised locally here.
Right. I mean, if he's deported, he can't be supervised locally. Now, we're all assuming he would have been deported. I mean, that's what, I don't know that would have happened. That's what they thought would have happened, right? But, so.
Okay, so let me back up a little bit to give a little, he comes to this country on a valid visa from Canada. He's only here a few days before he's arrested on this. So he overstays his visa because he's in jail.
Okay.
Is that your understanding?
I'm not really sure how long the period was that he had overstayed his visa, but it sounds about right.
Okay,
Yeah.
so he overstays his visa because he's in jail and he can't get out.
Right.
And I may be wrong, but it's my understanding that when you're subject to deportation, the agents don't come get you and immediately put you on a plane to Canada. You have some sort of hearing process that you're entitled to.
That's right. Right.
And you generally post a bond. They may come and arrest you, you post a bond, and you have a hearing whenever immigration officials can get to your hearing.
Yes.
Is that your understanding as
Right.
well? Am I
Right.
making this up?
Right.
So to say that he would have been arrested immediately upon being released from jail and be gone and no longer subject to our court's supervision is not necessarily the case, is
Right.
it?
Right. That this was all just kind of,
Speculation.
well, yeah, I guess it was a concern for the district judge. And I've seen this happen, where someone gets placed on probation and then they get deported. So I think this judge was basically just, I think he just couldn't reconcile these kind of concepts. But I've also seen people that not get deported, that get placed on probation in Johnson County. And
But even if he were not deported, he wouldn't, he couldn't lawfully be employed.
Right, and those people still get put on probation in Johnson County. So I guess they work around it. Maybe it's or they don't. Maybe it's a cash transaction. Maybe they're not supposed to be employed, or maybe there are people that can't work that are disabled that get put on probation.
Well, yeah.
But-
I think that's an exception, isn't it, on the community
Probably.
correction rules?
Probably that
And this guy isn't disabled.
Right.
He's operating under a legal disability in
Right.
the sense that he can't work. He's not permitted to work.
Does everybody that's been placed on probation in Johnson County have to be on probation through the residential center? Aren't there any people that are on probation that are just,
unsupervised, like an unsupervised probation.
or a
Or-
supervised
Yeah.
probation where they're not at the residential center? Aren't there
Right.
lots and lots of
Right.
people on probation that aren't at the residential center?
Right.
Well, that's what court services is for.
Right, and so
They're
this,
supervising,
yeah,
So
but it's the level
it's a level.
of supervision they need, and
Right.
here, wasn't the PSI, the pre-sentence investigation recommended community corrections?
Right, so I think there's standard probation like that, you would kind of have to be physically present for, but I think that the idea here was that there was a program available, you just needed to work with this guy and tailor it to him and his situation. So I think I would kind of dispute that, that kind of attitude, that there was just no program available. And that's what the judge said, there's no program available. But it was more that our standard community corrections program might not have worked at some point.
And what about, could you talk a minute about the durational departure too, and how they got to that and
Right,
what the
and
judge?
The only thing I just want to say on the dispositional is, and I'll get to the durational, is, there's this legislature wants people like this to be on probation. It doesn't want them going to prison. So, the durational departure, the state said there were two non-statutory factors, the sophistication of the scheme and the number of victims. And my argument on that is that's why he was convicted of a lot of things. That's why you had so many convictions. And again, the legislature said if it's property crimes, you can have 40 convictions. We're still going to cap it. We're still going to give these people probation. So this was already factored into the convictions themselves. And then the other part is that there was a lot of evidence about stuff that he wasn't convicted of. And so basically the state's saying, like, for example, he had a computer and there was a whole database. Let's see, what did they say? There were hundreds of numbers. Apparently it was some sort of, so there was some evidence, there must have been some sort of scheme where they obtained the numbers through hacking or when people skimmers at gas station pumps. And then somebody probably sells these numbers and somebody else then uses the numbers. There's some kind of scheme here. So you had a computer that had hundreds of numbers on it. So again, there's this thinking, well, you're part of this bigger scheme, but he wasn't convicted of that. I mean, this was sort of explanatory evidence for the judge as to how this all came about, but he wasn't convicted. What he was convicted of was what he did here in Johnson County, not some bigger scheme that may take place out there. And so the judge said, well, yeah, these are substantial and compelling factors, the sophistication of the scheme and the number of victims, but why that justified a departure in this case? Because there was already a number of convictions in place. I think that's kind of my argument. And the sophistication of the scheme, he wasn't charged with that. That was all just kind of explanatory stuff.
Any other questions?
Okay.
Thank you.
Good morning, Your Honors. Jacob Gonteski on behalf of the state of Kansas, the appellee in this case. I agree with the court's characterization at the outset, and Ms. Davis's characterization, I believe it was, that this is a case involving very interesting and somewhat unique circumstances, unique facts. Mr. Santapalai came to the United States with a computer, with a re-encoding device, and with hundreds of blank gray plastic financial card stock with a magnetic stripe on the back. None of them were embossed with names or numbers on the front. And when the defendant got a motel room in Johnson County,
And am I right, it was just shortly after he arrived?
it was within weeks.
Yeah.
He arrived in the country early January of 2014.
14, and this
he was
happened
arrested
Yeah.
arrested late in the month.
Right.
And in terms of, I'll jump all the way ahead, in terms of sophistication of the scheme, there was evidence that these numbers had been compromised. The credit card numbers that the defendant was using had been compromised in Canada at gas station pumps months earlier, and that there had been fraudulent use of those cards from Canada all the way down to Kansas, in Minnesota, in Wisconsin, and other states. There was discussion by the bankers who flew in from Canada to testify in this case. So in terms of sophistication of the scheme and number of victims that support the durational departure, what he was convicted of was possession of the re-encoding device and multiple counts of identity theft and theft. The average, the normal identity theft and theft conviction that you would see out of Johnson County, Kansas involving credit cards would be a 1 or 2 or 3 off, stealing a purse out of a car in a parking garage and dashing off to the Quick Trip and using the credit card for a tank of gas real quickly. That's essentially the same, somewhat the same facts, using somebody else's credit card without authorization to obtain goods or services, property for yourself. This was more sophisticated and more involved than that in terms of the whole network that was involved. This is not somebody who was doing a 1 or 2 or 3 off event. This is an individual who had a computer with a database within it with hundreds of card numbers. It didn't just have the 16-digit credit card number. He had the credit card number, the expiration date, and the PIN, all saved in text files on his computer. He could then plug the encoding device into the computer and take a blank gray credit card stock, and through programming on the computer, through the program that was installed on the computer that was testified about, he could then encode that credit card number on the back of the card stock that he had by swiping it through that encoder. And he could take that card stock and re-encode it with another number the next day, and so on. Within his database, he had notes in there as to what the daily withdrawal limit was on different accounts, so that he would try to stay below that limit to not trigger fraud alerts and that sort of thing. So the defendant took handfuls, stacks of these gray cards, re-encoded them. On the front, on the face of these cards, was with a Sharpie marker just written a number in the corner, and these cards were all sequentially numbered. They weren't numbered with the credit card number, but just 1, 2, 3, 4, 5, and he had 100 and some of these cards. Several more were found in his car and in his motel room.
And what's the point of that?
He would then, the text files that were stored on his computer, he would get daily text files that had several or dozens of credit card numbers, and the file was stored under a date, like January 27th. And then presumably on January 27th, he would encode 20 or 30 cards with those numbers. And in the text file, card number 1 would have a 16-digit number and a withdrawal limit and a PIN, and then card number 1 that he had in his hand would be that card, and so on. So the defendant then, when he was spotted, in terms of issue number 1 in this case, the defendant claims there was not probable cause to arrest him at the outset. It was more than just astute DEA agents observing somebody on foot at an ATM, because what happened was that morning, 2 agents were in an unmarked car, and they were making a coffee run, and they were going to the ATM, pulled up to the ATM, and they observed an individual in front of them on foot. They noted his dress because it was cold outside, but he wasn't dressed in warm clothes. He had a Batman sweatshirt on and some rolled up jeans with some bleach stains. They made these notes. And they observed him transacting business at the ATM in front of them as they approached the ATM in their car, and he was on foot. They waited for him. He then walked away. They pulled up and conducted their transaction. While they were leaving their transaction, they observed the defendant, and it's at a busy intersection where it's mostly commercial businesses.
It's 95th and Antioch.
95th and Antioch, I believe you're correct. And they're at one corner, I believe the northwest corner at a bank. And when they conducted their business and left the bank, then they observed the defendant walk across south, across 95th, to another bank on the other corner. And they said, that's odd. They noted it to themselves. And then they observed him go to a third bank on the opposite corner across the intersection and appear to conduct more transactions.
Well,
So
he
they
went to stores, didn't he? He went
did.
to the CVS and the
and a
7-Eleven.
Right.
But we don't know what he did inside.
We don't know if there were ATMs inside and so on, because that wasn't followed up upon. But he did stop in those businesses. So the agents pulled off to just watch what happened next. And they observed him walk to a parking lot and get in a vehicle. There wasn't anybody else in the vehicle. So he had been on foot in cold weather conducting all these transactions at ATMs with his car parked nearby. He then got in his vehicle and left. They pursued him, not with lights and sirens, but they followed him. They got a license plate number and a description and so on. But then he was able to lose them. They described him as driving quickly and evasively through the area, and they were behind him for a while but couldn't keep up with him. So they went back to work. They went back to the office. And as they described it, they literally stood around the water cooler that morning, discussed what they observed with other agents at the DEA office, which was not near that intersection. It's at a different area of Overland Park. They discussed it with Agent Holder and another agent and went about their business for the day. And then after 5 p.m. that day, the other agent who heard this story relayed to him, who wasn't there on the coffee run in the morning, he then was leaving work, and the DEA building is not prominently marked as being filled with DEA agents. They don't want that. They don't want to be known. They even talked about how they recognize that federal law enforcement authorities are targets for crime. So it's sort of a nondescript area. He was leaving work, leaving a secured parking lot, and he noticed in the parking lot adjacent to his own a single vehicle parked in the parking lot, in a parking lot which ordinarily hadn't been used for quite some time because that office building is vacant. And he saw a car parked there. He proceeded on down the lane, saw an ATM and an individual on foot at the ATM with the same Batman sweatshirt appearing to conduct transactions. And the car that he looks back and sees in the parking lot appears to match the description of the one he heard at the water cooler in the morning.
Talk about dumb luck.
Absolutely. They testified at multiple hearings about how they were just astounded at what they saw. So he pulled over, he pulled off the side of the street there, and then yelled at the defendant, this individual who was walking away from him at this point, walking in a direction different from where his car was parked. He yelled at him to stop, and when the individual turned around, he had several of these gray cards in his hand, and he said nothing more. I believe he said, I need an attorney, and that was it. So that was the extent of his knowledge and evidence at the time he stopped him and arrested him. I believe that constitutes probable cause to arrest this individual. As Agent Holder put it when he was testifying, in the totality of what he had heard in the morning and then what he had observed with his own eyes that afternoon, his words were, I believe there was some nefarious ATM money scheme going on. And he was proven correct. He was very astute in his observations and in his gathering of all this information. So
You don't have a whole lot of time left. Can
Okay.
we get to the
Absolutely.
durational and dispositional departure pieces?
certainly. In terms of the dispositional departure piece, Judge Draghi went out of his way to state he was not sending this individual to prison solely because of his immigration status or his status as a citizen of Canada and not of the U.S., but because he had heard extensive evidence of there not being a program, a probation option for this individual that he could comply with.
But
We
Judge
heard-
Draghi's the judge.
Correct.
Judge Draghi can make whatever probation
Correct.
criteria he wants.
Absolutely.
If he wanted to put this person in the residential center and say, you'll be in there even though you're not working, or you'll be in there and do community service and go to a community service job, he could have done that
He absolutely
easily.
could have done that. He absolutely could have.
So really, even though he said numerous times, I'm not doing this just because you're an undocumented alien, what other reason was there?
Well, it
I
wasn't.
mean, aren't we kind of splitting hairs here?
In a sense, we are, but in Martinez was the other case, and that's cited in both of, I believe it was Martinez, cited in both of the briefs as being the case involving an individual who was found to be non-amenable solely because of his immigration status. And the argument in that case had been made by the state that by being here illegally, he's committing a crime just by his mere presence. But in that case, there had not been any testimony about whether he had been deported in the past and whether or not he was actually committing a federal offense. Because just being here on a first-time event, overstaying a visa and so on, or walking across the border does not necessarily constitute a federal offense. So they didn't get far enough in Martinez to determine whether or not he was committing an offense at the time by being here. And Mr. Santaplaya was not. That was not the evidence in this case, but the evidence was from DHS, who testified before Judge Draghi. He does not have work authorization.
Right.
When he is released from the Johnson County Adult Detention Center, whether it's on bond or whatever the circumstances are, when he's allowed to walk out of there, we are going to arrest him and take him into federal custody. They didn't say he would be put on a plane and flown back to Canada that day. You're absolutely correct that it's not just a one-step
There's a process.
There's a process involved, and it's absolutely lengthy and so on. And so he would be afforded his due process rights regarding his immigration case in immigration court, which would be a separate proceeding. But the fact that he would be taken away and put into ICE custody would necessarily then indicate, at least for a time, he would not be able to report, he would not be working, he would not be able to satisfy the terms of essentially any form of probation short of something entirely unsupervised.
But if he's in custody, you have the best of all worlds. He can't do anything if the purpose of probation and these restrictions is to make sure you don't get in any more trouble, it's a dual-edged sword. He's either gets to bond out and wait until he has a hearing and comply with the probation here, or he's in custody.
That's true. That's true. I can't dispute that. I can't dispute that. In terms of the durational departure, I believe
Before you get to that,
Sure.
the pre-sentence investigation recommended probation.
It did because probation was presumed the level
Well,
of
that's
offense.
right, the level of offense.
Right, he was presumed probation.
But did they recommend community correction supervision, or did they take a position?
When you brought that up, when when defense counsel was up here, I wish I had the PSI with me. I just don't simply recall. He does not have an extensive criminal history. And so, frankly, I would be surprised if he had scored as community corrections, although the only way I could see they may have increased his score is if they factor in immigration status. And I don't know if they do. So I don't have his LSIR score in front of me to know whether or not his LSIR recommended court
But if-
services or community corrections. He was
I
arguing
could
that
see a certain argument if some policy arguments to say, if you're at community corrections, you're not, and you're in the residential center, you need to be out at work unless you're somehow disabled and can't, and are physically unable to work. Because I can imagine some conflicts if every morning, everybody in community corrections gets up, alarm goes off, they go off to work, and this guy sits there drinking coffee all day. I can see that there's some, but he could be supervised by court services, like most criminal defendants are, right?
right, he absolutely could be. As I recall at sentencing, he was explicitly requesting probation to the residential center. He was requesting either to be allowed to go back to Canada and supervise there, or if he was not to be released from physical custody, he was requesting probation to the residential center. Those were his two requests. Either let me go back to Canada now.
Did he say
or-
why he wanted to go to the residential center?
I don't believe he did. The only rationale that I can recollect would be then he would not be getting taken into federal custody, ICE custody,
Oh.
for the immigration case, and he would then be able to, if he remained in Johnson County custody, he would be able to time out his probation to complete the case. I know in similar
So
circumstances.
would ICE come in and nab the guy if he was if he was released to ordinary probation?
I believe so, yes. That was my understanding of the testimony from the DHS official. I know ICE agents have staked out the probation office before, I'll put it that way, to be frank. I mean,
Right.
they go there when they know individuals have appointments. So my understanding, my recollection was DHS had testified he had no work authorization, he had no lawful status for overstaying the 6-month visa, and if released from custody, he would be arrested by them. So I believe that pertained to whether he was released outright on the case, terminated, or released in some form of probation that was not custodial, not the residential center, for instance.
So we have an abuse of discretion standard, I guess, on this issue of whether or not probation should be granted. And that usually means an error, court committed error of law, error of fact, or did something so nutty nobody else would think of doing that.
I like that description of it.
Here, I assume you're arguing an error of fact when he says the only way to, well, I'm sorry, you're not arguing this at all. I
Exactly.
assume that.
That's why
I'm sorry, I'm getting ahead. I
Right.
assume that the defendant is arguing that there's an error of fact in his conclusion that there's no way for us to handle this short of a residential center.
Right.
And are you conceding that there are other ways that this could be handled?
I'll concede that the trial court absolutely had the authority to authorize other forms of probation. But from what I have seen in similar circumstances, and I know we already heard about other cases involving other defendants with similar immigration issues, courts are loath to lessen probation requirements for somebody who does not have status as a result of their status, out of concern that they will be seen as giving a benefit to an individual who is here without lawful status. Another individual in Mr.
But
Santaply's
again, we're
shoes.
getting back to the real
Theoretical.
reason behind all of this
Right.
is his immigration status, not
Right.
anything else.
If Judge Draghi had heard from Dave Thomas with Community Corrections, I can facilitate a program that will work even though Mr. Santaply cannot work, even though ICE may try to get him. I can formulate a probation that will that he can comply with, then I don't think Judge Draghi would have been able to make the conclusion that he did, which was to find a substantial and compelling reason to depart. He didn't have to find beyond all reasonable doubt there's absolutely zero programs available and my hands are tied. We don't have to go that far to, you don't have to go that far to affirm Judge Draghi's conclusion here. What you have to find is that your de novo review is that there were substantial and compelling reasons to depart. And here there were. There were substantial and compelling reasons to say this is not within the framework of the presumed guidelines.
Doesn't it seems to me, though, that Judge Draghi is relinquishing his authority to community corrections.
He wasn't entirely relinquishing it because there have been plenty of times in the past where he has countered probation officers with different conditions on a probation. So I don't believe as though Judge Draghi was operating under the premise that his hands were tied by probation. But he was not in a position, I don't feel as though he was taking the option seriously of giving him a lesser form of probation by virtue of his inability to comply with heightened probation.
Thank you.
On the duration?
On the durational departure, sophistication of the scheme and the number of victims, I believe I touched on that at the outset.
You argued that. Did Judge Draghi ever hold that? Did he ever make he's required to make findings as to why he's granting this departure. Did he make such findings?
He did. On the durational departure, he specifically stated as much when he said, this is not a typical fraud. This is sophisticated. An individual, and then he had been presented with evidence involving the sophistication of the scheme about the encoder and all of what I laid out at the outset of my argument. That was the testimony regarding the durational departure phase. And there were hundreds of numbers that Mr. Santapply had. He was not charged with identity theft on every credit card number that was in his possession. He was charged and convicted of 30-some counts of identity theft and theft related to actual transactions he had conducted at Johnson County ATMs in those 3 days that he was here in Johnson County. But the evidence was he had many more cards in his possession. Other card numbers that he had in his possession had been compromised elsewhere in other states and so on. And so there was a much larger operation going on here than just the discrete offenses that were charged and that occurred here in Johnson County. So even though Judge Draghi in issue number 3 did not state on the record, I find this is sophisticated because of these reasons, and I find that these reasons constitute substantial and compelling reasons to depart from the presumed guidelines because they're real and not ephemeral, they're actual, and they force me to stray from the guideline. He did not state the law when it comes to departures. He did not recite the statute in terms of what
And we
he
kind of
needed
have
to do.
cases that say you don't have to exactly cite the statute, but you do have to somehow tie them together. And I don't, we're in a position where we're trying to cherry pick what he said to say, well, okay, that must be what he meant. And isn't the whole idea that the court's supposed to make findings, specific findings, so that we're not doing that? In fact,
agree.
I think one of the cases actually says that.
Right, I agree. And that's not, it's not your duty to try to pour through the record to
Right.
find what his findings were, and I agree with that. But I believe if you go through the departure phase of this case, you'll find that Judge Draghi did make the necessary findings. He was so involved in the departure phase that while witnesses were testifying, after the guilt phase was concluded, during the departure phase and state's witnesses were testifying, Judge Draghi was interjecting questions to them, both with probation and with the sophistication of the scheme and DHS witnesses and so on. He was asking them questions about the facts, circumstances of this case. He was intricately involved in trying to determine whether or not the departure arguments the state was making had been satisfied. So my argument is he made the necessary findings on the record, even without using any magic words.
Okay, thank you. Any other questions?
No, thanks.
Thank you.
Okay, Ms. Davis, I have a few minutes to,
Actually, I'm going to waive rebuttal unless the court has questions.
Well, I have a question.
Okay.
The veil still needs to be lifted on a few things here.
Okay, try to help.
So let's assume the court you have shown that the court abused its discretion on the dispositional departure of not granting probation. If it goes back, the court could say, well, let me ask you, could the court simply say, okay, those heavy-handed judges up in Topeka have sent this case back, and so here we are in a resentencing, and on the departure, my finding is that I believe that in this type of offense, if you're going to be on probation, I insist that you work. And because of the defendant's status as being unable to engage in lawful employment, I simply can't put him on probation, and off to prison he goes.
Right.
Court could make that statement. Would that be satisfactory?
Well, that's the problem here, because the legislature has mandated probation. And so a judge, I don't think a judge could do that, could say, well, I can't give you probation because you can't work.
Well, he could say, well, that's my substantial compelling reason.
Not to. Yeah, but I think that still goes back to the alien status. I mean, basically, if you uphold the district court in this case, then you're saying that anybody who's in this country that doesn't have alien status can be denied probation.
They'd all have, yeah.
I mean, they could all be denied probation
Well,
because a
it's
judge.
been, I think the state points out cases from, aren't there all kinds of cases floating around that where they found that you're not amenable to probation because of your alien status, you're not able to be engaged in lawful employment?
I haven't seen that so much. I've seen not amenable to probation, but usually that's based on behavior. Where the defendant hasn't done something, like they've shown they can't comply with the probation. That's where I've seen that. The alien status, you know, it goes both ways. He was in jail for 22 months on a presumptive probation offense. And I bet he didn't bond out because of that reason, right? Because he doesn't have ties to the community, because he's from Canada. So, I mean, it goes to say, well,
He
if
was
you...
only on a 6-month visa.
Right.
He didn't plan to stay here forever anyway.
Right.
You
So
know,
they're not-
this was a
right.
hit-and-run operation, wasn't it?
Right, so they're not going to grant him an OR bond. So he spent 22 months just before sentencing on a crime that if other people were convicted of who were Johnson County residents, they would maybe have never served a day in jail.
In fact, it would seem to me that he could put himself in a position where ICE does get him, and then he can waive all his rights, and they can immediately send him back to Canada,
Self-deport. Yeah.
self-deport, and
Right, but-
and he skates out with
But what's-
without any kind
right,
of
but
probation.
what's he skating out on? And is probation something in itself? Is that like post-release? Is that something that has to be, or does it have a purpose? I mean, what's the purpose of probation, right? Is it that you aren't going to violate the law? You know, that we're going to, I mean, what is it? So it's like, if the whole thing is just you have to serve this supervised probation for so long, just for it in and of itself, then the district court, that attitude is justifiable. You can't go to community corrections, right? If that's the whole point. And if the point of
It's the
probation.
alternative to sending you off to prison. You know,
Right.
The alternative to sending you off to prison
Right.
is sending you to Disneyland for a week. That's hardly.
Well, it's kind of giving you a second chance, isn't it? If you can show you're not going to violate the law, you're going to be a good citizen, we're going to give you a chance to avoid prison. But, you know, if say he does get deported to Canada, he's pretty much saying, I'll do anything you want from Canada, right? I mean, he could report from Canada, right? But you've got to tailor probation for that. So again, it's just, do you say the district court judge, you can do a probation. If the legislature says you have to give him probation, there is some sort of probation that can be crafted here with him in Canada, and putting requirements on him, and I don't know what they would be because he's already paid restitution, but which I think is the main one in this case. But assuming you wanted to put some requirements on him, you could supervise him from Canada. They
So,
just didn't. They just weren't going to explore that option. They were not going to go past their mold, basically.
And I don't know if you have the answer to this, but, you know, they found $82,000 in his motel room that was forfeited. Did
Right.
I mean, was that $36,000 in restitution? Was that somehow taken from the $82,000
You know, I don't
that
know.
was forfeited, or do
Yeah.
you know, or did he come up with an additional $32,000?
I don't know.
Okay.
And I imagine all of it was probably seized eventually,
Right.
but I don't know the answer to that.
Okay.
So it's a difficult question, but again, it depends on whether, you know, in terms of the, we're basically arguing here that his alien status cannot qualify as a substantial and compelling reason for a departure. So as a matter of law, that's not sufficient. And so when a district court judge here says there's not a probation program for him, that was never really explored at this hearing. Basically, they said our standard probation in this case does not match what we think is going to happen to this person. So that's not what the legislature says. The legislature doesn't say you have to give them community corrections probation and they have to do X, Y, and Z. It just says probation.
So if the court hears evidence that ICE is standing ready to nab this guy, and he was only here on a 6-month visa anyway, and the reason he's still here is because he's in jail in Johnson County, and he's asking for probation, and as soon as he's on probation outside of the clutches of Johnson County authorities, he's going to be nabbed by ICE, and then he could voluntarily give up his rights and be extradited.
Right.
Would that be, and that probation is an alternative to prison, would that be a basis for denying probation? Simply, that is, that if he is placed on probation, the way it is likely to play out, there will be absolutely no consequences to him at all. He'll be back in Canada next week and free as a bird.
And that's true of a lot of defendants. There's a lot of defendants that you grant probation and they're gone. I mean, you know, they don't do the probation. I mean, that happens in other cases, right? So that by itself
Well, does that, you know,
that by itself isn't a sufficient
my
reason.
mother told me, just because everybody else does that make it right?
But I mean, that's not a sufficient reason, because for the court to say there's no probation program available to him isn't true. The probation program in Johnson County might not have been available to him, but he can go to Canada, he can call his probation officer, he can say, I'm sending you verification, I'm working, I'm paying my court costs, I'm not violating the law.
Why would it even have to be in Canada? Why couldn't he be on probation in the United States?
Well, I'm just assuming I'm assuming he got deported. And if he did, that doesn't mean he can't do the probation. He can just do
Could he
it.
have done house arrest?
He can do it by distance. Hey, sure, I mean, you can say he doesn't have to do it because he's not in the jurisdiction, but that's true of a lot of other people. See, other people take that attitude, I don't have to do the probation either. And maybe he wants at some point to come back to the United States. I don't know. I mean, maybe he has an interest in complying.
I have a feeling based on these convictions
You
that
don't
it's
think-
gonna happen.
He's not going to be welcome. Okay. So I just think it's dangerous if you say the alien status, I mean, basically, is the basic reason here, and that's a reason to deny a dispositional depart. I mean, that's going to be a blanket prohibition, because every judge in every county can just say, you can't fit our mold. So,
So they're getting at it one way when they couldn't get it at they're getting in it indirectly what they couldn't do directly in the.
well, it just
Yeah.
depends. If you want to give the deference to the legislature and say, sorry, judge, you're going to have to come up with a different mold. I mean, it's just whether you want to give that deference to the legislature or whether you want to give it to a district court judge.
Well, the only reason that other case got reversed is because Judge Kitts said, every day you're on
Right.
probation, you're committing a new crime.
Right, and that was a-
And the probation says, terms are, if you commit a new crime, you've violated probation.
Because he would have been in the country in violation of federal law, right?
Which is not accurate.
Right. I'll conclude my comments.
Thank
Okay.
you very much.
Thank you.
Just 1 second, let me finish my notes here. Okay, that concludes our morning docket. We don't have many people that have made it through the whole morning, but we would be happy to take any, and counsel, you are free to leave or you're free to stay if you want to answer questions as well. Does anybody have any questions they'd like to ask us about how the court works or what happens next or where?
What's the most difficult case you've ever tried?
You
Is
want
there
to?
one that stands out more than most?
This is, well, he's thinking of that, and it looks
Yeah.
like he'll come up with one. I'm asked that question a lot, and it's very difficult because as a judge, we hear hundreds and thousands of cases. And you spend a lot of your time focusing and writing an opinion on one case, or as a trial judge hearing one case. And when that's over, you kind of shut it down and go on over to the next one. So to try to sort through those files is kind of difficult. But Judge McEnany's had lots of interesting cases.
Well, as an appellate judge, setting aside work as a trial judge, probably one of my most difficult was a case arising out of Wichita. Wichita has for a long time had a real gang problem. And it was a drive-by shooting in which someone was killed. And the defendant's argument was, as is often the case, I wasn't the one who, I didn't pull the trigger, I didn't do it, it was this other guy. But at the trial, the court didn't permit some testimony that would have pointed to the fellow that the defendant claimed was the real trigger man, and the guy who, in fact, defendant says, I wasn't involved in it at all, it was all this other guy. And one of our problems is that we hear so many criminal cases, about 70% of what we hear are criminal cases. And a lot, well, let's say a substantial number of those really don't have, the appeals don't have a lot of merit. Our job is to try to wade through all that and not miss what's maybe the needle in the haystack. And in that case, I was convinced that this guy had gotten a raw deal, and wrote an opinion that sent it back for a new trial of a gangbanger involved in a drive-by shooting where somebody got killed. And boy, that was tough to do. But a week after that opinion hit the street, the fellow who the defendant accused of actually being the trigger man, he came forward and confessed that he did it. And so the state didn't retry this defendant and wound up prosecuting the right guy. So it worked out fine in that situation, but it's kind of tough when you're going through some of those cases, particularly cases coming from a community that's just has had a terrible problem with gang violence. And when you reverse a conviction like that, it's tough. Particularly, we have the benefit of not being elected judges. We stand for retention every 4 years. It's a lot of community pressure gets placed on judges, and can be placed on judges in those situations. And our job is to withstand that public clamor and really decide the case independently.
I can't think of one.
Well, I can tell you another, it was just one we talked about today.
He always has stories.
In which the case they're talking about, it was one in which I wrote the opinion having to do with a denial of probation to a fellow who was an illegal alien on the theory that every day he stayed in Kansas on probation, he was committing a new crime. And I reversed that along with the other judges on the panel and wrote the opinion that was published. And I can tell you, did I get a whirlwind of emails and tweets and angry when it was published in the newspaper about the outcome. You know, that's one of the things, that's part of what goes with the job, that kind of public outcry sometimes to our simply applying the law.
Thanks. Uh-huh. I can't see that far.
In that case, were you able to determine whether or not a Brady violation occurred during the introduction of evidence?
What case are you talking?
the one you were talking about out of Wichita related to the gangbanger. And
Was there a Brady issue?
information had been provided related to his testimony, or I'm not really.
You know, I don't know. I don't think it came up in that context. It was basically, and I can't remember all the details. It was basically that the prosecutor hadn't been forthcoming about this information that had to do with this witness who, if called, they might have been able to put the screws to and get him to admit that he was really the trigger man.
Understood. That's why I was wondering if there was a Brady violation involved with that.
Not per se, as I recall.
And
Thank you, Your Honor.
for everyone here, what a Brady violation is would be that the prosecution had some evidence that would tend to show the person was innocent, they didn't disclose that to the other side. Or at least not guilty.
You know, I think all of us, I mean, I think we always have in mind the fact that we know there are false confessions. We know there are people that are convicted by juries that may not have committed the crime, and it's the needle in the haystack that you're trying to find. You know, is this one of those cases? Is this one of those cases where this person really was railroaded through the system somehow? And
If you want a fascinating read on these kind of cases, a really good author is John Grisham, who usually writes novels. He wrote a book called An Innocent Man about two guys who were prosecuted for murder down in Ada, Oklahoma, and this was it is a not a novel. It's a true recounting of that. And it shows how the wrong that had been committed in the handling of these cases went through a number of courts until somebody finally, in fact, it was a law clerk to a federal judge who was reading the file and saw that needle in the haystack that everybody else had missed. In the meantime, two innocent men had spent considerable time in prison. And that's the situation as judges we all live in fear of, that we miss that needle in the haystack. We got to find them. That's our job.
Did you always know you were going to be a judge, or just got into practicing law and that's how it came about? Or
I always knew I wanted to be a lawyer from the time from as young as I can remember. I remember wanting to be a lawyer. I don't recall once I got to be a lawyer thinking I wanted to be a judge. It just kind of, I told somebody once that in law, and I'm sure in all other professions, your work or your profession you don't necessarily pick it sometimes. It kind of picks you. And so just the way things fell, an opportunity arose, and I took the opportunity and was selected as a judge. But it really wasn't something I planned up until that point. What about you? Did you always want to be a judge?
Well, no, like you, I think I always wanted to be a lawyer. I come from a family of lawyers. My father was a lawyer. My grandfather was a lawyer. My sister's a lawyer. My son's a lawyer. We have a lot of lawyers in our family. And I practiced law for 27 years before I went on the bench. And I went on. We heard today about a case where a lawyer was serving as a pro tem judge. Well, that's a lawyer who has a considerable amount of experience that the judges will call in to cover, say in the event a judge is sick and can't take care of the cases. Rather than continue them, they'll bring somebody in. Well, I got to do that several times, and I really found that I enjoyed not being so much the advocate for just one side, but being able to sit back and try to decide cases on the merits, and as opposed to just being an advocate for one side. I don't take one bit away from the advocacy role of lawyers. It's important. It's one of the it's what makes our system work. But I'd done enough of that, and I was ready to do something else.
What about you, Judge Green?
Well, I'm more like Judge McEnany. I really enjoy the practice of law. I practiced law for 18 years and had a mixed practice of criminal law and civil law. And I was not really interested, as far as being a judge, but I was asked, as far as a nominating committee member, as far as the appellate system, to put my name in to be considered, as far as the governor being appointed. And that happened in 1987, and I did make the list, the short list of 3. The nominating committee would select 3 names and then send it on to the governor, and I wasn't selected. And it, you're kind of disappointed, but it was kind of relief because I just went back to practice law, and I had never even thought about doing it again. But in 1993, a person on the nominating committee asked me to put my name in again, and that time I was selected by Governor Finney. So what I'm saying to you, if I was not a judge today, I still would be practicing law. Because I really enjoy the work with people and their individual cases. And some of the cases my partner and I really like to do with adoption cases and things of this nature, when we were taking a family and allowing them to adopt a young child and seeing the glow and things of this nature, or sometimes things that you actually took for granted because you're doing your job, and someone will come up to you 4 or 5 years later and saying, well, because of what you did, really changed my life and you helped me. Those kind of comments was really rewarding for me. And in a way, I kind of miss them because we don't get those kind of comments. No pats on the back anymore. So I'm like Judge McEnany. I really enjoy the practice of law, and if I wasn't a judge, I would still be doing that, God willing.
Any other questions? Okay, well, any questions for the lawyers here, if you want to? No? Okay.
I was just, and I was paying close attention that you were weighed in, this is your first argument before the court? Or?
It is. I'm actually a third-year law student. And my law license was on the line.
Mr. Minahan decided the case that he knew would get lots of questions should go to the intern.
Okay, I changed my mind. I have a question.
Oh, sure.
It's not really towards the cases, but what would you say would be the best skills that someone could go into law school with? Or maybe a better question would be, what's a good undergraduate degree? Or something to focus on? Because my aunt's a lawyer, and I've heard that she's like, she recommends the sciences, things that are analytical. I'm just curious what you guys would say.
Law school, you have to read a lot.
Yeah.
You have to go through a lot of material. So do that.
Okay.
A lot of material where you have to read and be comfortable writing, I think.
English. And what you
I was an English major, so that's fine.
Yeah.
That's perfect.
And what you already touched on, I think, is one of the cornerstones, anything that's really analytical, because if you went through the 7 of us, there's probably 7 different degrees. My undergrad was meteorology, but it's a hard science.
So weatherman.
It's analytical. I love chemistry and atmospheric science and so on. And I thought it played well when I got into law school, but I had that analytical background. But other people in law school, I don't think the standouts in law school didn't all come from one type of undergraduate degree. It wasn't like just the political science students did well, or just the English students did well, or just the sociology students did well. It was all across the board with all kinds of different backgrounds. And even just getting into law school, it's all about just having a rich background of experiences. It's not, a law school isn't going to shy away from you because of your undergraduate degree. It's going to be kind of the richness of all the experiences that you've got that they're going to draw on in terms of admitting you. So.
I agree with that too. I was one of the people, when I went to law school, everybody was saying, oh, you need to be a political science major to get into law school, and so that's what I was. I don't know that my political science background did much to assist. I had another degree in psychology. That was much more helpful. But I often tell people English and journalism, because as a lawyer, you have to be able to take a complicated set of facts and kind of narrow it down to something understandable and persuasive, and that's what a journalist does. So I think those are really good backgrounds too. But counsel is right. There are a wide variety of backgrounds in law school, and they each bring something different. And some come for different reasons. I mean, somebody may have an undergraduate degree in engineer, and they want to go into patent and trademark law so that undergraduate degree helps them. But
In fact, it's required.
yeah.
If you want to practice be licensed as a patent attorney, you have to have a degree in hard science, engineering, or one of the
What was your
basic
undergraduate
sciences.
degree in, Judge McEnany?
A real hard science, philosophy.
But philosophy is good
That's
too,
good. It's a good,
because
I'm a
Judge
very- I'm
Green
a-
here is a big philosophy fan and logic.
I'm an advocate for any of the liberal arts degrees. I mean, this is a people business. You're dealing with people. And the more experience you have in that broad variety, I would discourage people. If you are bound and determined you're going to do nothing but corporate law, then maybe you can be a business major or accounting major or something like that.
If you want to do
But if you're-
tax law.
If you're going to do tax law. But from my experience, people go into law school thinking they know what they want to do, and as soon as they get out, all that changes.
Right.
You know, you shouldn't limit yourself, and that's why I think a good, sound liberal arts education gives you the broadest scope.
What was your undergraduate degree in?
Political science
Oh, well,
and
you were-
history. But I go along with Judge McEnany with philosophy, some logic courses, because what we do as a lawyer and as a judge, it teaches you to think critically. And many times, another thing, what some of the attorneys were saying is that generally, if you're just practicing law, it's probably 70% or 80% writing because you find motions, briefs, and things of this nature. And it's like what we see on TV when you stand up in a courtroom. Really, as a real lawyer, you probably have written 70, 80% of your time preparing motions and briefs and things of this nature. So as far as actually that time in court is very short compared to your actual writing. And one of the things that we see, as far as critical thinking is that in the philosophy major at Judge McEnany, what helps you is it allows you to see fallacies. What we see in some of the briefs, begging the questions, red herrings, things of this nature. And once you can see it, and once you could put a name on it, then it helps you when you're writing and replying to some of these arguments that they're making. It makes you a better writer, stronger writer, and allows you to think critically. Don't you think, Pat?
I agree with everything you say, Henry. I always do.
And if you want to see philosophy at work in judicial opinions, look up some of Judge Green's judicial opinions. He makes more philosophical arguments with regards to, I can't even pronounce, syllogisms.
Syllogism, right.
And fallacies than anybody on our court, probably anybody around. He's very good at that, at recognizing those things. Anything else? Well, thank you all very much. We've enjoyed our time here. Thank you, Professor Nadelman, and it's been a pleasure to be here. We will stand adjourned.